So I've had the pleasure of working with Dr. Minkus for most of 12 years now. And he is an industrial engineer who then started to study and practice law. And he's currently the associate dean at the Sandra Day O'Connor College of Law. He may tell us that himself, but for now, what I'd like is if anybody's having trouble hearing it, please send me a chat so I know to adjust a setting. This material is also going to be on Canvas for later viewing. But let's start right now. If you need anything, send a chat. I will watch for that.
Hello. Welcome to an overview of intellectual property. It's a way of protecting innovation. My name is Professor Eric Minkus. I am a professor at the Sandra Day O'Connor College of Law. A brief introduction. I currently, in addition to being a professor, am the Associate Dean of New Education Initiatives. That means that I help run all of our master's degree programs. These are one-year degrees in law that don't allow you to practice law. However, it gives you an education in the law for those that don't want to be practicing attorneys and do the 3-year law degree. I run our continuing legal education program. I run all of our online education, and then executive and continuing education as well. So let's move on. To get started,
How far should I back up? Question mark. Let's try again.
Run all of our online education, and then executive and continuing education as well. When I'm not being an associate dean, I am a clinical professor, and I direct the Innovation Advancement Program, which is an entrepreneurship program at the College of Law that helps small companies start their businesses. And then all of the courses that I teach have an entrepreneurship focus, and most of them are multidisciplinary. So a lot of times it's lawyers in the room with, well, law students in the room with engineering students and or business students and or science students. That's sort of my passion, is teaching right at the intersection of law, business, and technology. So let's move on. To get started, I'm going to give a little brief overview here in this first video. And one of the basics for understanding intellectual property is what makes something property at all. And most people, when they talk about what makes something property, talk about things like, well, you own it, or that you bought it, those types of things. But really, what makes something your property is the ability to exclude others. So when something is your property, what really happens is that you have the right to exclude others, and you have the right to enlist the government's help in excluding others. For example, if someone is in your yard, your property, and you do not want them there, you can ask them to leave, and if they don't leave, then you call the government, the police in this case, and have them forcibly removed. With intellectual property, it is having the government, the courts, say that someone is infringing on your intellectual property, and then you have damages. You can get an injunction, keeps them from doing it again. You could get money damages, to get paid back. There's lots of different things. But again, the government helps you exclude others. So keep that in mind. That is a key tenet for property. Let's talk a little bit about some of the language differences. In IP, the language is different than what we would call real property or what real estate a lot of us think of as everyday. So in regular language, we talk about selling your property. In intellectual property, we talk about assigning your property. In everyday language, we talk about renting a property. Here you would license intellectual property. And if you inappropriately acquire, steal, or convert, you're either going to infringe or misappropriate in intellectual property. And we'll get into all of those phrases a little bit later in the lectures. But there is some language difference, and I'm hoping that you can understand the difference between those two. So how do you create intellectual property? Well, sometimes you need to file a legal document. A patent, you have to file a patent application. If you want to register a trademark, to get a registered trademark, you have to register it with the government. Same thing with a registered copyright. However, occasionally, just the actions of the holder can create intellectual property. You don't actually have to file anything with the government. For example, trade secrets. You don't have to file and tell the government your secrets. You can have an unregistered trademark. You have unregistered copyrights. There are rights that are created simply by you doing something without actually filing with the government. So why do we do it? The first one is, as I said earlier, excluding people, namely the competition. You want to be able to get intellectual property that excludes your competition from doing what you're doing, or using the name that you're using, or using the recreating the play that you've written. So it's a way to exclude competition. There's some others here on the screen. One of them are sort of intellectual assets, or intellectual property is valued, and so you can create extra value by having intellectual property for a company. Some other advantages here. You might want to keep others from doing something like patenting in an area. You don't really want to operate in an area, or you don't really want to enforce your patent against others, but you want to keep others from being able to patent and keep you from doing something. And also, a lot of times you need to have, for example, a registered copyright in order to be able to enforce and sue. So there are reasons for getting formal intellectual property. Does IP really matter? So here, this is old data, but what we're really looking at here is the gold portion of the graph is intellectual assets, and the white portion of the graph is physical assets. So if you add up all the buildings and cars and computers and all of that stuff owned by companies, this is the proportion. So in 1975, which doesn't look very good on the screen here, but in 1975, intellectual assets only made up 17% of the total assets of the S&P 500 companies. However, by 2010, you can see that switched to 80%. And that makes a lot of sense when you think of, especially today, companies like Google, Facebook, Twitter, all of those types of companies, the sort of new economy. Really, when you add up all of their physical assets, their buildings and computers and ping pong tables, I guess, at a lot of these companies, you're not going to get a huge value. At least you're not going to get a value anywhere near the total market value of the company. So you can see here that intellectual assets over time have really become the primary value within companies. So really there are 4 types of protection that we're going to go over in these lectures. The first is trademarks. We're going to talk about copyrights, patents, and then trade secrets. So patents have relatively strong protection, and the public policy there is you must disclose your invention to obtain exclusive rights. So patents you absolutely have to file with the government in order to obtain rights. You cannot obtain rights without filing. Trademarks protect logos and names of companies and those things, and that protection is based on continuous use. As long as you continuously use your trademark, you have rights. Here you want to actually protect the consuming public. I want to know that the Coca-Cola I buy from the store is made by the company in Atlanta, Georgia, or at least like the company headquartered in Atlanta, Georgia, and not by some small company down the street. You want the public to know that certain items and services are made by certain people because they convey information. Copyrights are actually fairly narrow protection. They get a lot of attention because they really impact, let's say, media and entertainment industries. But it's actually fairly narrow protection. We'll go into what that means, but it's automatic to achieve. When you do something like fix something in a tangible medium of expression, then you are going to have copyrights at that time, and we will talk about what that means. Now, you need to register to enhance your legal rights and remedies, but you actually get protection just by fixing in a tangible medium of expression. And then trade secrets, you never file with the government. It protects information so long as it's secret, which means possibly forever. When you think about the formula for Coca-Cola and the spices of Kentucky Fried Chicken and many other things, they're really trade secrets. They're potentially vulnerable. All it takes is one person telling the world about them, and they're no longer a secret. So they're fragile, I guess is the best way to put it. But you do have lots of different things that can be covered by them, and they can have an indefinite duration, which makes them attractive for many companies. All right, so that is our first lecture, and if you have questions, please send them to Professor Fleischner, and he will get them to me, and I will try to reply to them either in a written reply, or maybe I'll record another lecture with answers to questions. Thanks.
So normally, when Eric is in class, he will let you know that we are covering 4 semesters of law during the period. It's an awful lot of material, and so I think it will be better to have access to it all semester. In this case, the first one is just introducing all of the concepts. And as we move forward, we're going to learn about each one of them, why they are useful, what are they doing for us, and what can they prevent us from doing. Give me a second while I change to the other video. This next video is on copyrights. And if it doesn't view for you, because I don't know if I have to reshare it, please text me. Just chat with me quickly so I know.
Hello, welcome back to Intro to Intellectual Property. In this lecture, we're going to talk about an introduction to copyrights.
Do you see that video right now?
So what is the purpose of copyright?
Thank you.
Copyrights encourage artists and scientists to create original works. Basically, we want to give them the right to exclude others so that they are incentivized, often monetarily, for doing these types of things. We like it that people are writing movies and writing computer code and sculpting and painting and singing and doing all the things that artists do. And in order to encourage them to do that, potentially even as a career, we provide them the ability to exclude others and control how their works are used. And therefore, they can often extract monetary value out of that. And many authors would not do that without it. And the theory is that we're a better place with more artists doing more artistic things. So what are the minimum requirements for a copyright? Basically, you have an original work of authorship fixed in a tangible medium of expression. That's it. That is the legal standard, and that is how a court would decide if something is able to be copyrighted. Now, obviously, you know that there are a couple different parts of this definition. So you have an original. So you have a question of, is it original? Then you have a work of authorship. Is it a work of authorship? And then is it fixed in a tangible medium of expression? And so all of those things are things that a court would look at and try and decide, hey, what's going on here? Does it meet the criteria? And then if it is, then it would be eligible for copyright. So if you're in business, what would be some interesting copyrights? You have the website content, you have software code potentially, marketing materials, product descriptions, emails, and even your logos and other things can have copyright protections to try and keep others from being able to use them in ways that you don't like. So the length of a copyright, so if the individual is deemed the artist, it is the life of the artist plus 70 years. Now the purpose of allowing post-death copyright protection is that often the types of work we're talking about really don't gain the value that they would until the artist is dead. You think of painters and musicians and things. Scarcity drives value, and because scarcity drives value, one of these artists either quitting or dying is generally what then ramps up the value of these things. So when it's an individual author, life of the artist plus 70 years. If the company is deemed to be the author, then it's 120 years from the date of creation. And we'll talk about how a company can be an author a little bit later in this lecture. So this is your bundle of rights. You have the right to exclude others from copying, distributing, displaying, performing, or creating derivative works of your copyrighted work. And so it's sort of like the pens here in the jar. These are the things that you can exclude others from doing: copy, distribute, display, perform, create derivative works. So it applies to the original expression, but not to the underlying idea. So here's a picture, and this picture right here actually has copyright protection, but that doesn't mean, so that is the actual original expression, but it doesn't mean that you and I, or you or I, couldn't go to San Francisco, stand in the same place, wait for a boat that looks very similar to float by and take virtually this exact same picture, because it doesn't protect against the idea of this picture, just this one particular individual expression. So another way to think of this is movies. If the idea of a movie is boy meets girl, boy loses girl, boy and girl get back together, and they live happily ever after, and you could copyright the idea, there'd be many fewer movies made. But you can only copyright and exclude others from your specific expression of that idea, not the idea itself. Therefore, many movies that follow that general idea can be made. So there's no copyright protection in facts. So if you read a news article and they are quoting facts in the news article, you can take those facts and use them elsewhere. Now, that doesn't mean you can copy the entire news article and post it elsewhere or use it elsewhere. It just means that the underlying facts are not something that are copyright protected. Now, the order in which the facts are presented, all of the language around how the facts are presented, those may be copyright protected, but the facts themselves are not copyright protected. So when does it happen? So it happens the moment that a work is fixed in a tangible medium of expression. So if you are taking notes on this lecture, as you are writing or typing them, you create copyright in those notes because you are fixing them in a tangible medium of expression. Putting the circle C on your work puts others on notice of your rights, but it's not actually required. But what it does, by putting others on notice, you are often opening up the potential for monetary damages. If you don't have others on notice, then usually you would only be able to ask for an injunction from a court. Along with copyright, is this notion of fair use. Now, fair use balances copyright. It's what allows us in certain scenarios to use copyrighted works in certain particular ways. And there's some pretty easy examples to think of, but this is almost always when someone gets accused of infringing someone's copyright, fair use is almost always their initial rebuttal or defense. So it can be wide ranging, but we'll talk a little bit about it. This is a huge part of a copyright class in law school, so we're not going to get all that deep into it, but just know that this is something that people can claim that allows you to use at least parts of others' works of authorship, even if they're copyrighted. So the Copyright Act includes this because we want to build on existing works and comment on existing works under fair use. It is a defense, it's not a permission slip. You only can claim fair use once infringement has been claimed against you. So it isn't something that you can use as a stick, you can only use it as a shield. So what makes something fair use? Did you use the underlying work in a way that transformed it? In other words, did you take a movie and then do a commentary, a social commentary on a small part of the movie as sort of a critique, or use it to help drive home a point? Now that might help you make a fair use argument. What did you copy? So what is it that your copying can make a difference? How much of the original use? And did you use the quote unquote heart of the original? In other words, if it's a 50-page book and you copied one paragraph, more likely, then it's more likely to be fair use. If you copied 49 pages of the 50-page book, less likely to be fair use. Also, it doesn't matter if you only copied one page of the 50 pages if what you did was take out the heart of the matter. In other words, let's imagine that it's a book about whodunit, sort of a thriller of who could have killed someone, a mystery novel of some sort. And the one page that you use elsewhere tells who did it. Well, then that is the heart of the original. And then finally, would someone accept your work as a substitute for the original? A lot of times, you might be doing something completely different with the work. So it's not really a substitute. And this kind of talks to what is the financial impact on the copyright holder? Are they going to still buy the original even though this new work that uses it is out there? Or would they use it as a substitute and drive down the economic value? The key here is that a court looks at each of these on a case-by-case basis in each situation. So there is no bright line rule in any of these. The court will look at these four factors, kind of give a measure on each one, and then decide, was it fair use or wasn't it? And there is no sort of easy way to say, if you do this, then it's certainly fair use, because it's case-by-case analysis. So why would you want to register? How do you claim infringement, and what are your damages? And we'll also talk a little about open source. So why would you register? So you register your copyright with the U.S. Copyright Office. And what it does is it establishes evidence of ownership nationwide. So everyone, even if they don't go look it up on the U.S. Copyright Office website, is deemed to have what we call constructive notice. So even if you don't look it up, you are deemed to have notice once you file and register it with the U.S. Copyright Office. If you want to sue for infringement, then you have to register. You pay an application and a fee, and you submit it to copyright.gov, either via online or via snail mail. It's not really a difficult process, but a lot of times you are doing the types of work, especially with things like computer code, maybe some videos and things that you may not want to copyright every revision of it, or even every video you do, to be able to sue others. So there is sort of a strategy here on what you want to file as a registration and what you don't want to file. So what can you get? You can get what's called actual damages. So if you can calculate the actual amount you lost, and then maybe add in the actual amount that the infringer earned due to the infringement, a lot of times court will give you that back. But it's hard to do those calculations often. Usually in patent and other areas, it's a little bit easier to do those calculations. So there's a second option here presented by the Copyright Act, and that is what they call statutory damages. So it just punishes them. It's not really a, hey, let's recoup the full value that you can prove, that you can do the calculation and prove what the full value is. It's just, let's just punish the person, the infringer, and it's somewhere between $200 and $150,000 per infringement. So if you go online and infringe 7 copyrights by right-clicking on copyright protected photos and then post them, all 7 of them, into a Reddit thread, then you potentially could be looking at $1,050,000 in statutory damages, or as little as $1,400 if it's proven. But you see here, this is where you punish people that are doing those types of things to keep them from doing it. And especially in today's world where infringement is really a right click away, it's really meant there to be a deterrent. So if you want statutory damages, you must register the copyright within 3 months of publication, or 1 month of learning of the infringement, whichever happens first, which means if you're going to publicize something, which has a very specific meaning in the law that we're not going to talk much about today, but if you're going to publish or publicize something, within 3 months, you should file it if you want to keep open the option of statutory damages. So what else could you do if someone is, you suspect someone is infringing? You could send a cease and desist letter. You could do a Digital Millennium Copyright Act takedown notice. Almost all websites now, especially those that allow others to post information like Reddit threads and message boards and YouTube and TikTok and all of them, will have a DMCA, Digital Millennium Copyright Act takedown notice provision. You can find that, and if you're the copyright owner, you can submit a request for them to take the infringing material down, and then they do a little bit of analysis, and once they do that determination, they either put it back up or they keep it down. Something a little more creative, not sure how much it's used, but you send the infringer a license agreement to use the work and send them a bill and say, hey, you're using my copyrighted work. Here's a license agreement. Please sign, return with this dollar amount, and you will now have a license or permission to use the copyrighted work. Remember, license in intellectual property is renting. So they don't own it, but they are renting the ability to use it. So open source software. Those of you that are coders should be aware of this, because often open source software that you can find out on the internet comes with a license to use it. Nobody reads it. It's usually a pop-up screen, and nobody goes through the trouble of actually reading the whole thing. But often they require that any software that the open source code is inserted into be distributed on the same terms as the open source code. And that often means that you cannot sell it. And if someone asks you for the actual source code, you have to send it to them. And so if you're trying to make money on an app and you've put this type of open source code into it, for example, then someone who would write you and say, I want the source code to your app, you technically would have to give it to them. Can't register open source code or really anything you create with it because of the way the license works. So it's hard to register anything that has open source code within it. All right, that is a brief overview of copyright. If you have questions, please submit them to Professor Fleischner, and I'll find a way to answer them for you. Thanks.
So one question that came up, these videos all came from a very large PowerPoint. Dr. Minkus used only part of that very large presentation, and I will try to reduce it down to only the material that we are interested in for this class. It's a presentation that he used with lawyers, for lawyers, which means there's a ton of detail that most of us will not need. I'm going to move on to the next part. As you see, copyright, one thing to note, many people will simply put the little copyright symbol and a date or a range of dates on their materials and consider it copyrighted. In fact, that's reasonably effective, but it comes to kind of when you did this. You can extend your rights, as he said, by registering at uspto.gov, I believe is the correct location, US Patent Trademark Office.gov, uspto.gov. But now let's go, in fact, to trademarks.
All right, let's move on to our introduction to trademarks. Many trademarks are things that we know in everyday life. You can see some trademarks here on this home screen that it is something that is really easy to know what they are. So we see them every day. Let me see if I can resume the slideshow. There we go. So let's see what's next. So what's trademark? It is a mark plus a product or service. It could be word, logo, color, sound, scent, package design. Basically, it can be anything that is designed to make you think of a product or service. So it could be a mouse, like Mickey Mouse. It could be a certain color, like color schemes that are famous. You know, Southwest color scheme comes to mind. It could be a sound, like the NBC chimes. Anything that makes you think of the source of the good and service. And we're going to use that phrase a lot in this section, the source of the good and service. So it's going to identify and distinguish the source, again, source of the goods and service. You basically use it in commerce in order to initiate the rights. So you don't have to file for anything. There is something called a registered trademark, but you don't have to do that. You actually have rights in an unregistered trademark. You use it, or you acquire rights by use in commerce. So why do we do this? We want to protect consumers. We know that two companies that sell beef can have very different messages to their customers via their brand or their trademark. So for example, Ruth's Chris is a steakhouse. McDonald's also sells a lot of beef. Two very different places, two very different experiences, different costs, different tastes. So you convey information to consumers via these trademarks, and that's what it's there for. It's not really to protect the companies. It's there to protect the consumers, so they know who made the product or service that they're buying. So use in commerce, bona fide use in the ordinary course of trade. In other words, you have an actual sale or an actual attempted sale. You can't just say, hey, Aunt Betty, I'm going to send you my product, and that gets you, the trademark started, because that's not bona fide use. That is a sort of fake use. You always want to put the mark on the good, or at least on the packaging if you can. In service marks, so trademark is for goods, service mark is for services, makes sense. You need the marketing materials plus the service actually provided. So those are what start a trademark for service marks. Again, token use, or the example of you just shipping it to your aunt, is not sufficient. It has to be real bona fide use. So how do you register? You file the application with the USPTO, US Patent and Trademark Office. You must update it periodically to inform the USPTO about marks you're using on the products, if you've expanded into different industries, all kinds of different things. And you can keep it as long as you use it. However, if you abandon it, which is no use of the mark for 3 continuous years, then it goes back into the public domain and someone else can use it. So why do you want to register? So you have exclusive rights to use your mark anywhere in the United States. Even if you're only using it in Arizona and Nevada, for example, you have the exclusive right to use the mark anywhere in the US once you've reached the registry. So what you do is you freeze competitors using similar marks into their established markets. So if somebody is in Texas using a similar mark, you can freeze them where they can't go out of the places they're currently using it. And then, of course, you use new companies from using a similar mark, or at least a confusingly similar mark. And we'll talk about confusion here in a little bit. So one is trademark, unregistered. The other is circle R, registered. That's the main difference. All right, so this is the cautionary tale. What you see on the left here is a small Burger King in rural Illinois. What you see on the right is what we all know as Burger King that started in Florida and then moved across the country. So Burger King on the right, Big Burger King, filed a federal trademark. So it is a registered trademark, and which gives them presumptive use in the whole United States. However, they started opening up new restaurants. They got to rural Illinois, and there's Burger King, and they sued them. They sued Little Burger King and wanted to enforce their trademark there. Well, it turns out Little Burger King was using the mark first. So they actually have rights that trump the Big Burger King. So what ends up happening, and what the court said, was you draw a ring around Little Burger King. I think it was 5 or 6 miles, something like that. Big Burger King can't open in there. However, Little Burger King can't open outside of there. And there's probably restrictions on advertising and things like that as well that go along with it. But you get the idea that just because a mark isn't registered, first use is the most important thing in trademark law. However, registering a mark can be also very powerful. Just so happened in this case, Little Burger King, unregistered in rural Illinois, was there first. And so even though Big Burger King filed the federal trademark and got it on the registry, there wasn't anything they could do here. All right, so let's talk about the different types of mark. So you can have what's called fanciful. Basically, this is made up. This is Kodak, Xerox, things like that. They don't really have a meaning. They're fanciful. So if you have that type of trademark, they can go right on the primary register, and that's where you want to be. Primary register is what gives you rights. Then there's arbitrary. Apple, that's a real word, but it has nothing to do with computers, or at least it didn't used to. Now it does. But there it is a real word, not a fanciful word, but a real word used arbitrarily. Again, those can go on the primary register. And then you have things that are suggestive, like copper tone. This copper tone, it suggests that you are going to get a copper tone, but it doesn't at all describe suntan lotion or use those words. So it can also go on the primary registry. Then there are things that are very descriptive. They're not generic, they're descriptive. So if I had a printing company and I called it Eric's Printing, it would go on the secondary register, which doesn't actually give me rights. However, over time, I can earn enough secondary meaning, is what they call it, meaning that people recognize Eric's Printing as me being the source. And once you can prove that, usually you do it through market research or just a matter of time can also do it. You move from the secondary register to the primary register, and that's where you want to be. And then things like soccer ball and other generic terms to describe a soccer ball or a soccer ball company cannot be protected. So in other words, if I make soccer balls with my company and I call my company Soccer Ball Company, that doesn't mean that you can't use the term soccer ball. It means that you can still have Bob's Soccer Ball Company, even though I have Soccer Ball Company, because I can't protect it. It's the generic term. Now, if I said soccer computers, now that's an arbitrary use of soccer. There, I can get on the primary register. But when I'm just talking about the good or service itself, then it is generic, and I cannot protect it at all. So this is why the name has to identify the source of good and services, not the good or service itself. One of the main key takeaways from trademarks. All right. Primary register, as I mentioned, is where you want to be. So your supplemental register gives notice of claim and allows you to use the circle R, but it doesn't give you full rights of being on the primary register. So if you have 5 years of continuous use, or if you can prove secondary meaning, again, usually with market research, the mark can move to the primary register. That's where you want to be. So plaintiff has the burden of proving that defendant's use of the mark has created a likelihood of confusion. Again, that's a legal term. That's exactly what the court will determine. Is there a likelihood of confusion about the source of goods and services? You can have lots of companies with very similar marks that aren't confusing at all. Delta Airlines, Delta Dental, Delta Faucets. They're all Delta. But nobody's confused. Nobody thinks that Delta Airlines owns Delta Faucets or that Delta Dental owns Delta Airlines. So there's no likelihood of confusion between those marks. And then here are the factors that they go through when doing this likelihood of confusion analysis. So you can see that, so here's a good example, physical proximity. So if they would sit next to each other on the shelf, there's more likelihood of confusion. But if one sits in aisle 10 and the other sits in aisle 1, or maybe even in a completely different store because they're very different products or services, then there's less likelihood of confusion. So you can see here, these are the factors that the court would use. After a while, something can become very well known, and then it can become what's called a famous mark. So again, the court looks at these factors. So you look at them and to try and determine, is this famous? And what by famous marks, what you really mean is nobody else can use it, no matter if there's confusion or not. So it basically removes the likelihood of confusion analysis once something is elevated to a famous mark. You and I cannot start Coca-Cola Landscaping Company. Really no confusion. Nobody thinks Coca-Cola, the company, actually owns that. But because Coca-Cola is a famous mark, we cannot do that. So it doesn't even require actual confusion. It's just a matter of it's so famous, you can't do it. This is really the main way is you claim dilution of a famous mark. You can claim it blurring, so the famous mark becomes identified with more than one type of good. So there you go, Xerox Plumbing, Coca-Cola Landscaping, so that is blurring, or tarnishment. So the famous mark is disparaged through the association with a low quality or unsavory product. So there's a case out there where someone opened Victor's Little Secret, which is an adult bookstore, sold adult novelties and adult toys. And Victoria's Secret sued them. No one actually thought Victor's Little Secret and Victoria's Secret was the same thing. So there was no actual confusion. However, because of the nature of what Victor's Little Secret sold, the court held that it tarnished the image of Victoria's Secret. There's also a case out there with, there are these urinal cakes made by Tiffany urinal cakes, and kind of packaged them to kind of look like Tiffany, the jewelry company. And again, that was tarnishment because of the nature of the good. So again, the key with famous marks is no actual customer confusion is necessary. So you want to protect your trademarks against genericide. So this thing right here, this is not a Band-Aid, it is a bandage. A Band-Aid is a brand of bandage. This is not a Kleenex. This is a facial tissue. Kleenex is a brand. In fact, a lot of people will say, I need a Kleenex, and they go over to a box of Puffs and they pull it out. Aspirin is actually a brand name for acetylsalic acid that became so tied to it that the mark stopped identifying the source of good and services and started identifying the source of good and services itself. And from that, they lost their ability to protect the phrase aspirin. Now, anyone, not just the person who started it as a registered trademark, but anyone can make acetylsalic acid pills and call them aspirin. This is not a thermos. This is a cooler mug or something along those lines. Thermos is the brand. It is the source of this good and service, but so many people call it thermos. You can think of others. People sit down at their computer, and even if they're going to Bing, they probably Google things, all of that. So when you lose the ability to protect a mark because it stops identifying the source of the good and service, but instead is so popular that identifies the source or it identifies the good or service itself, that's called genericide. And aspirin has actually experienced it. Some of these others have not, although if you go to the store and look at Band-Aid, it'll say Band-Aid brand bandages. All right, trademarks can't be functional. So someone came out with a tennis ball that is this bright yellow color that we're all familiar with, and then tried to trademark it and say, look, this yellow ball identifies our particular tennis ball company, and nobody else should be able to do it. But it turns out this color yellow is very functional. It is actually the best color for seeing the ball both at high speed and later in the day or early in the morning. So there is some function to this aspect of it. Therefore, you cannot protect it with trademark. You might be able to protect it with patent, by the way. All right, you want to do a search? You can look at the U.S. Patent and Trademark Office databases. You can look at state registries. I would definitely look at web searches and yellow pages, because remember, it doesn't have to be registered with any government in order to have rights, and potentially superior rights to yours if they used it first. So if you're going to start a company and you're going to pick a name, you should be looking at all of these. I mean, yellow pages not anymore, but web search engines and USPTO database for sure. But I'd also look at the state registries in the states that you think you're going to do business. Just make sure that someone isn't out there using it already and could block you from being able to use it once you spent a bunch of money to create branding around it. All right, finally, there's a intent to use application. And this is where you tell the government that I'm going to use this mark in the near future. You can use it for 6 months, or it's good for 6 months, but you can extend it for up to 6 months increments. So you basically, they come back to you and say, yes, you meet all of our requirements, except you have not yet used it in commerce. And you don't have any actual rights, but the moment that you use it in commerce, you send them, you prove it, you have a federal registration at that time. So this is a way to speed up during the process where you're developing a good or service. This is a way to speed up the trademark application process, because you do all of it except the use in commerce. All right, if you have questions, please send to Professor Fleischner, and I'll get back to you. Thanks.
Key takeaways for trademarks are: first to use. Fun fact, last semester, we actually had one student that lived near Little Burger King, and it was a fun conversation. We've also had fun conversations over music sharing and things of that nature, where people not knowingly, not intentionally, were violating these rules. Now on to patents. Once again, if you have questions, go ahead and type it in the chat, and we'll be close to wrapping this up.
All right, let's get into some patent law. This is probably the most famous area of law. So patents allow for a limited monopoly, which in our economic system is huge. We do not like monopolies, but they allow for a limited monopoly, which is a right to exclude. This is your bundle of rights here. You can exclude others from making, using, selling, offering for sale, or importing your patented invention. So again, that's really important. Your bundle of rights. You can exclude others from making, using, selling, offering for sale, or importing your patented invention. They're only good in the United States. All of the intellectual property we're talking about today is only good within the United States. All right, so a patent does not secure a right to practice the invention. So that seems weird, right? Like, you go through all the trouble, it can take up to 3 years to get a patent. You go through all that trouble, you are issued a valid patent by the U.S. Patent and Trademark Office. However, you may not have the right to practice the invention. So here's what the example I'm going to use. So here is a three-legged stool. Imagine that I have invented this. I got tired of sitting on stumps and rocks, and I invented this three-legged stool, and I got a patent on it. So I own the patent for the three-legged stool. You sit on it for a while and you get your back starts hurting. So what you do is you put a back on it right here. You put a back and you call it a chair, and you get a patent on the three-legged stool with a back and you call it a chair. Well, it turns out that you cannot make any chairs because I can exclude you from making the three-legged stool. Now, there are lots of different things we can go through, and we will later, having to do with, well, what if I added a fourth leg? Or what if I use different types of legs on the three-legged stool? So there are some variations that we can talk about later. But right now, if you had my stool with a back and you called it a chair and you got a patent on the entire chair, you cannot make it. Now, keep in mind, this incentivizes us to work together. Let's take our law hat off and put on our business hat. You could buy the stools from me and put a back on it and sell it as a chair. You could just sell backs and say, hey, go buy Mankis's chair, or go buy Mankis's stool and put this on the back, and now you have a chair. So there's lots of different ways that we can work together. But if all you want to do is manufacture the entire thing, you cannot, because I can keep you from manufacturing the subject of my patent. It makes sense, right? Just because you get a patent on a car doesn't mean you also have the ability to make every single piece inside that car. There are patents on transmissions and braking systems and all kinds of things that you can't just go do because you got a patent on the car overall. So it makes a lot of sense when you think about it. All right, one of the keys here is that patents are actually very strong protection. They protect against both innocent copying, where you didn't know that I had a patent on it, and reverse engineering. You buy my product and you reverse engineer it and figure out how it works. You still can't make it. Now, let's contrast this with others. For trade secrets, for example, you just keep something secret. Innocent copying or reverse engineering limits any protections of trade secrets. It's no longer a secret, so that's okay. Also, in copyright, if you and I just happen to write the exact same story, let's say we're writing a very short story, and you and I write the exact same one. However, we did not copy each other. We just did it separately. We did not infringe on each other's copyrights because we did not copy. So you get the idea that patents are actually very strong protections. The public policy for patents is actually in the U.S. Constitution. That's how important it was to the founders of our country. It's actually written right in Article 1, Section 8. And so this isn't something that was kind of devised afterwards. This is in the actual language of the Constitution. So why do we have it? Sort of what's the reason for it? So what we want to do is we want to add to what we call the reservoir of accessible knowledge. Why do we want to do that? Well, let's think about the way science and technology works. Science and technology generally is either trying to figure out how something works or trying to solve a problem. So those are really the two things that science and technology really does. And if I told you that we wanted to try and solve problem X, the first thing you should go out and do is access the reservoir of accessible knowledge. Today, you might go to the internet, but you want to go access the reservoir of accessible knowledge and try and figure out how have others tried to solve this problem, and what can we learn from them before we go and try and repeat all of that. So patents, what they do is they grant you a quid pro quo, a limited monopoly, if you disclose what you're doing. And then what the USPTO does is they take what you tell them, and you have to tell them a lot about your idea, and they put it up on the internet so that they've added to the reservoir of accessible knowledge. But in exchange, you now get a limited right to exclude others from making, using, selling, offering for sale, or importing your patented invention. However, what's now happens is your patent application is online, and I may be trying to solve the same problem or a similar problem. I can go read it and say, oh, look how this person did it. That's really creative. However, I know how to do it a little bit better. And then I can go, and technology moves forward step by step in that way. And so if all you had to do, the only way you could protect your ideas was to keep them secret, the reservoir of accessible knowledge would be much smaller. Science and technology would move much slower. That's sort of the theory behind why we have them. All right, these are what you need. You need patentable subject matter, and we're going to go over each of these in a slide. It needs to be new, useful, non-obvious, which is a weird word, we're now identifying this person of ordinary skill in the art that we're going to talk about. And then the inventorship means that you were the or one of the actual inventors. So if you saw somebody else doing something and you were not an inventor, you cannot get a patent on something. You have to give an enabling disclosure, which is sort of, you have to tell the government, when I said earlier, you need to tell the government a lot. You need to tell them how to do it so that a person of ordinary skill in the art, think of your average, if you make chairs, your average chair maker would be able to read what you tell the USPTO and go make your item without undue experimentation. In other words, you can't hide the ball. And then, of course, it's the government. You have formalities and you have fees. So you're going to file paperwork and you have to pay money. So what are some patentable subject matter? Machines and devices, processes, methods. A lot of times, business methods now and software patents need to be tied to devices. So there are some additional things you need to look for. But any patent attorney that you work with should be able to help you with that. Compositions of matter. Business methods, again, a lot of these are software now, and they need to be tied to a physical item. So make sure if you have a software patent that you work with an attorney on that one. And then plants and designs. We're not going to talk a lot about that. It's a very niche area. I don't know a whole lot about it, honestly, but just know that there are certain types of plants and certain designs that you can actually get a patent on. All right, so I think this is important. As we're learning about the law, most people try to put on their lawyer hat and they look at everything from a legal question. But the legal question here is, can I get a patent? Did I meet the requisite things I needed to meet in order to get a patent? So that's a legal way of approaching it. Should I get a patent? It's a business question. Patents take a long time. They can run you up to about $30,000, $40,000, $50,000 sometimes. So that is a business question. So are you going to get a return on investment, and how? That is the business side of it. And you need to answer both of these questions if you're going to go for a patent. So I always use this as kind of a joke, but this is an actual issued patent. It's a bird diaper. So someone got tired of picking up after their bird by using newspaper, I would suppose, at the bottom of a bird cage, and they decided they were going to invent a bird diaper. Someone spent a lot of money and some years getting this issued back in 1997. So it was filed in 1997. So yeah, so that's when it was issued. There you go, 1999. So you can see there, it took a little under 2 years to get this one issued. And this is fairly basic. So can you get a patent on this? Sure, no problem. It's a novel concept. It meets all the requirements. However, should you? I don't know. Maybe this person's a millionaire making $1 million on bird diapers. I doubt it, but maybe they are. I don't know the industry very well. All right, let's talk about this person of ordinary skill in the art. So this is important in your obviousness and enablement analyses. So would your invention, if this person of ordinary skill in the art knew a lot about what else was out there already, would your invention be obvious to them? And again, this is a person of ordinary skill in the art, not advanced or limited skill in the art. This is like your average chair maker, your average engineer, your average bioscientist. So where can they be found? The answer is nowhere. This is a legal fiction, but the USPTO examiners are asked to put themselves in this person's shoes and examine your patent in a way that the person of ordinary skill in the art would examine it. So is a PhD a person of ordinary skill in the art? No, they're a person of advanced skill in their art. If you were starting a company, you probably aren't a person of ordinary skill in the art either. You were probably advanced unless you're just very early in the process. Otherwise, you know a lot about what's going on if you're trying to start a business in there. All right, what can be prior art? So prior art is key. Prior art is what is used against you. You filed with the U.S. Patent and Trademark Office, and you say, you should give me a patent on this. And then what they do is they go out and they find prior art. And they look up lots of different things, and they send it back to you. And they say, look at all this prior art. It anticipates your invention. You should not get a monopoly for this. Sorry, no dice. So what kinds of things can be used? Patents worldwide. So if something is patented somewhere else, you cannot get a patent on it here. But there's a couple exceptions. If you are the person who patented it elsewhere, that you do get some time to patent it here. But you can't just go to Spain, for example, see something, see a patent in Spain and then patent it here if you're not the inventor. Publications worldwide. So some engineering professor in Germany writes a paper, that could be prior art. Is it on sale worldwide? Public use worldwide? So this was expanded back under the Obama administration under the American Invents Act. There's not a lot of leeway here. In the United States, if you disclose it yourself, you get a 1-year grace period during which you have to file a patent. But it basically eliminates international rights. So if you tell somebody about your invention before you file a patent, you might have had an inventor's own disclosure and then start a 1-year window from that day that you need to file a patent during that time. So again, the person of ordinary skill in the art looks at the prior art and determines obviousness. So novelty. This uses a single prior art reference, one patent, one publication worldwide, and compares your invention to that one thing. So basically, if your exact thing hasn't been done before, you're going to skip over this, no problem. Utility and usefulness. This isn't a difficult hurdle. This is where they throw out things like perpetual motion machines and time machines, and then occasionally you get someone who tries to patent something they don't really know how to use. They just know it's new, and that gets thrown out here. And then obviousness. This is where you take multiple prior art references and the examiner can say, here's a US patent, and here is a patent in Canada, and here's a patent in the UK, and then here is a publication from a professor in Japan, and combine all those together. And then they say, look, this person of ordinary skill in the art with all of this background information, all of this prior art, your patent or your request for patenting this invention is obvious. So therefore you do not deserve a patent. And that happens all the time. Lots of things get thrown out on the obviousness hurdle. So we are now a first inventor to file system. This happened back in 2013. We used to be a first to invent system. So let me give an example of what this means. If I invent something today and you invent the exact same thing tomorrow, and then the day after you go and file a patent, and then the day after you go, I go and file a patent. In the current system, you win. We are now a first inventor to file system. You were the first inventor to file. Under the old system, if I could prove that I invented it before you, I would win, and my patent application would take priority. This is new. It saves a lot of bickering within the USPTO and gets us in line with most of the rest of the world, but it also puts a lot of pressure on small inventors, because you used to be able to rely on being able to prove an invention date and go from there and not have to spend the money you need to spend to get a patent. Now, there's a little bit of what they call a rush to paper. You invent something, you feel attention to get a patent application in so that a competitor doesn't get in on that idea before you. So we went over a lot of this. The key is you have to be an inventor. Again, if I invent today and you see my invention and then go file, you are not an inventor. You have to be able to prove that you're an inventor. If I'm the inventor and you're the copier, you are not an inventor filing. So it kind of it helps keep some of that sort of idea theft away. All right. So enablement. So if you have a new way of doing something, you have to describe it in your patent application in a way that a person of ordinary skill in the art would know how to practice the invention without undue experimentation. So they'd read it and pretty easily be able to make it or do it. This is where the specification, which is the description, and the drawings are important. It can be difficult to hide the ball. You also have to do what they call a best mode. So you have to say, not only is this what it is, but here's the best way we know how to make it, or the best way we know how to do it at this time. The good news is you do not need to update either of these. Once you file, those are frozen. All right, for patents filed after June 8th, 1995, you get 20 years from the earliest US filing date. So if you file today, you'll get 20 years from today. Now, if you happen to run across a patent that was filed before June 8th, 1995, it's 17 years from the issue date. Now, the only way you would get let's see, 17 here plus 1995, so you'd be at 2005, 2012. So basically, you would have to have somebody who has had the patent application linger within the USPTO for 7-8 years in order to still have something that would be valid today. But you get the idea. What happened down here was because it was 17 years from issue, you had a lot of people that were incentivized to keep their patent application pending in the USPTO to keep pushing out the date. Where here, you actually have incentives to get it through the process and get it issued because you only get 20 years from when you file. And of course, there are ways to have it expire early. One of them is almost always stop paying fees. All right, so provisional patents. These qualify as a patent application. All it does is set an application date. You describe what your invention is and you send it in. You don't even have a specific form. There's lots of stories of people using the back of a bar napkin as a provisional patent application. And it doesn't really get reviewed. It gets a date stamped on it. But later, when you file a full application that says, okay, this is my full application, the provisional that I filed earlier, though, that's the date that I want to claim on this one. So then you have to say, okay, what you sent in as the provisional, that bar napkin, for example, does it anticipate what you sent in the full patent application? So if what you described on the bar napkin was parts A, B, and C of your invention, but then in the full application you have A, B, C, D, and E, you might have to break your later patent application to 2 applications. A, B, and C can claim anticipation and the date of the provisional, but D and E cannot, and has to be a separate one, and today's date, or the date it was filed, would be the actual date on that patent application. So provisionals, it's much cheaper to do. You don't really have to work with a patent attorney to do these, but you need to be careful because if they don't anticipate, then you don't get that earlier filing date. And if you've done things in the interim where you think you're going to get the filing date and you don't, you could actually really impact your patent rights during that time. All right, co-inventorship. All inventors have to be listed on the patent app. So even if you only invented a little bit of a invention, you need to be on there. If you're not, and the USPTO thinks you were left off on purpose, then they can actually invalidate the patent. In a weird way, each listed inventor upon issuance owns the entire patent. It's kind of like if you and I owned a house together. If I'm a 1/3 owner, I paid $100,000 and you paid $200,000 toward a $300,000 house, and we're co-owners. That doesn't mean that I only own the second guest bedroom and the guest bathroom and the part of the kitchen with the refrigerator in it. No, I own the whole thing, just like you do. Now, we might have different monetary rights to it, but we each own the whole thing. And in patent law, we can each assign, which means sell the patent. We can license the patent to someone, or we can otherwise dispose of it, and there's no accounting required. I don't have to tell you about any money I made, nor do I have to share it with you. Why is this there? I'm not really sure. I'll be honest with you. I haven't looked up why this scheme was created. However, there is a way to handle this, and that is to assign a patent to a company. And then company owns the whole thing. The co-inventors own the company, and decisions are made about the patent via how decisions are made in the company. So that's the easiest way. You can also just draft a contract between co-inventors, but I'm a big fan of forming a company, putting the patent in the company, and going that route. I think it's a much cleaner way to handle it. All right, so this is where every inventor who's worried about a patent says, I have to keep this a secret. So the key here, if you're going to have an enabling public disclosure that's going to impact your patent rights, this starts the 1-year window. It has to be a disclosure, but it has to be enabling and public. If you just run outside and say, I cured cancer, that is a public disclosure, and that's a public and a disclosure, but it's not an enabling public disclosure. Similarly, if I am in a room with someone who signed a non-disclosure agreement and I tell them exactly how I cured cancer, that is enabling and a disclosure, but it's not public because that person's under a non-disclosure agreement. So you need an enabling public disclosure. So this can be a bar to obtaining a patent, especially internationally. I told you it starts a 1-year window here in the United States. It pretty much eliminates international rights. So how do you handle this situation? This is really tough because people who you want to go raise money from are often being pitched by many different people, and they're not going to sign a non-disclosure agreement right away. So generally what you do is you talk about outcomes. You say, I cured cancer, and here are the results, and you show them the results. And if they're interested enough, then they'll be willing to sign an NDA. But this is actually a really tricky thing. If you need the money and someone's not willing to sign an NDA, you have a very hard decision to make on how do you handle the situation. Another way to do it would be file a provisional patent. Then you have a date. It's a little bit risky or a full patent, I guess, but most people don't have the money for a full patent. So you file a provisional, it puts a stake in the ground for a date, and then you just hope that your later full application will be anticipated by it, and that you can claim that earlier date. Then when you have this enabling public disclosure, no big deal. You've already filed a patent, you have a date. So it doesn't start any 1-year windows. All right. So let's do some quick examples here. My buddy came up with a great idea, but is too busy to pursue it. Let's patent it and build a business. He won't mind. That's the second bullet here. That's a problem because you're not an inventor. You need your buddy to be part of the team. So he won't mind implies that person's not going to be part of the team. So you need the inventor to file. I want to patent the name of my company, not patentable subject matter. Name of the company is, we learned about it, trademark. Their patent expired last year. We can make their product. So that one I think is actually true unless they have what they call an improvement patent that patents something else that's an improvement on it, and you want to make the whole new and improved thing, then you might be blocked. But you can certainly make their old product that has fallen into the public domain. So John and I are co-inventors on this patent. We own it 50-50. Maybe monetarily, but not in rights unless you take steps, either contract or putting it into a business to affect that. All right. That was a very fast walk through patents. I'm sure some of you have some questions for me. Submit those to Professor Fleischner, and I'll see if I can reply with answers. Thanks.
Okay, I think that's plenty for today. I noted on the chat that I will upload the trade secret video. It's definitely worth watching, and I will try to make the PowerPoint a reasonable size. If you have questions, email me. Otherwise, have a good rest of your week. Thank you.
I have a question.
Go ahead.
Hello? So how our test is going to work, because I think we're having a test next week. So how is it going to work?
I have not yet formalized that. I did note on the text that the test, once I know how it will work, I will announce it.
Thank you very much.